Let me talk a little bit about provisional patents and the problems that are associated with them. With provisional patents, the way they work in theory is this. You file a provisional patent before you disclose your invention to anyone. Then you use that year of provisional protection to disclose your invention, take it to the trade shows, start that Kickstarter campaign, go out and get a bunch of feedback from users, things like that. And then by the end of the year, you've had enough time to accurately assess whether or not you want to put the money into the full utility patent filing or not. So that's the way it should work. Unfortunately, there are a lot of ways that people misuse provisionals, and we're going to go over those next. The first problem that people run into with provisionals is the cheap inventor who decides they don't want to pay the money for the provisional, and instead they want to test the market first. And so they go out and they get a trade show booth, they show their invention around at a trade show, and they disclose it. Then they wait a couple years, maybe at the trade show nobody was that interested, so a couple years after the trade show somebody calls them up and says, I met you at this trade show and you had that product. I found somebody who's really interested in manufacturing that. They'd like to license your patent rights. Can you tell me what your patent pending status is? And the inventor just says, we're provisionally filed. And they quickly go out the next day and they file a quick provisional patent. And then within a year they do everything right. They turn that provisional into a utility application. The utility patent is eventually granted on their application. So they've spent probably $10,000 on this. And they say, well, I've got a utility patent now. I'm covered. Well, they aren't. Unfortunately, anyone who has a copy of that, the trade show brochure from that year that they were at the trade show, if they happen to flip it open and there on page 13 is a picture of the inventor holding the invention up in the air with the head of the trade show next to them, that is very, very good proof that they publicly disclosed it more than a year before they filed the provisional application. Therefore, their own public disclosure can count against them. And a lot of inventors say, well, that's not fair. Well, the reason the law is in place that way is to force inventors to either, okay, if you've got an invention, either try to patent it and try to protect it or give it to the public. And so that's why there's that one year bar. And so under 35 U.S.C. 102, you have basically 1 year from the time you first publicly disclose your invention until you have to have a patent filed on your invention. Otherwise, your own public disclosure can count against you. So that's the first situation of somebody who discloses the invention, waits more than a year, files a provisional application on it, and in essence they've thrown away their chance to patent it successfully and avoid any challenges to it by waiting more than a year from their first public disclosure until they filed their first patent application on it. A second problem that a lot of inventors run into is where they first disclose, then they have a very poorly prepared provisional application that they then turn into a utility patent application claiming priority from the provisional within the year. Now let's follow this along in the timeline. So what happens here is they disclose the invention, then let's say a month later they file a provisional on it. However, instead of having a good provisional filed on it, they went to elcheapoprovisionals.com, got the $99.95 special, got a provisional that was drafted online that was basically worthless. They filed it with the U.S. Patent and Trademark Office. Then on the anniversary day, in the last 5 minutes that they could do it, they filed a utility patent that claimed back priority to the provisional filing date. And even if the utility patent was really well prepared, the first thing the examiner is going to do when they're faced with a utility that claims priority from a provisional is they'll look at the provisional and see whether the provisional provides adequate support for the utility. And if the provisional does not provide adequate support for the utility, the examiner is going to reject the provisional date and give you the filing date of the utility. So in this particular case, unfortunately, the utility filing date is more than a year after the inventor's public disclosure. So once again, the inventor has disclosed way too early and is not able to protect that disclosure by filing a patent application with a priority date less than a year after it. So this is the second way an inventor can really shoot themselves in the foot, by filing a very poorly drafted provisional and then trying to turn that into a utility once they've disclosed the invention first.